Hi there, this is Erica Maryland. I'm the founder of Perfect Legal Video, and I am very excited to have with us today attorney Nicole Reeves Lavallee. She has a family law firm out of Worcester, Massachusetts, and she's just fantastic. I'm going to warn you. Today, we're going to talk about a very interesting topic. We're talking about conciliation, and if you listen, Nicole will give it to you straight. Welcome, Nicole.
Thank you for having me.
You are welcome. So let's get right into it. What is conciliation? Let's talk about the definition before we get into all of the nitty-gritty details.
Conciliation is a form of ADR. So ADR is an alternative dispute resolution. It's a way to resolve your case without the need to go to trial. You may already be in some kind of litigation, but it's a way that we're going to narrow the issues down, or we're going to settle the entire matter in a conciliation session.
So let's talk about how to even decide if a case should be a conciliation case.
Well, you can certainly decide it. My suggestion is always to talk to your attorney about your case and whether or not it's right for you. My answer is it doesn't hurt. Any case can be conciliated. So whether you're in housing court or district court or superior court or probate court, every place has a room for conciliation. So it doesn't matter what your litigation is, you can try to conciliate and resolve those issues. So I do think it's beneficial. And I think the other thing is, you want to do it sooner rather than later. A lot of times you do need to get your discovery, you need to get that responses, you need to kind of know what your good things and bad things are with your case and what you realistically are going to be able to get. So you do have to have that done in the meantime, but you don't want to wait to the eve of trial to conciliate. Often in superior court, that's exactly what happens. And you really don't have much to lose by not settling a conciliation matter. But when you're in family and probate court, you're conciliating right after pretrial. So you're looking at 8-9 months down the road of saving yourself a lot of time and aggravation and obviously money. So I definitely highly recommend it for any case at any point in time, but obviously, again, sooner rather than later, as long as you have your discovery done.
If it doesn't work, it doesn't work, right? There's no harm in trying. Would you agree?
That's absolutely correct. In all of the cases, the conciliators are working for free. So they are attorneys that are doing this pro bono. So they're giving up their time to help you. So they genuinely have a motivation to resolve the issues. They don't like wasting their time and going, well, that was a waste of time. I got absolutely nowhere. These parties are going along their separate ways and they're going to go to trial. That's not giving them a warm fuzzy. They want to do it. They want to resolve that issue themselves, as well as obviously you want to resolve your issues, and sometimes maybe only resolve 1 or 2 issues. You can do that too.
And that makes a lot of sense. It makes sense to sit down and try to handle these issues before you have to go through a whole trial. Because you're right, the time and the aggravation and really your health and your well-being have a lot to do with being in a situation where you're stressed out, your life is changing, you don't know what's going on. The sooner you can find out what's going on, as long as it's fair, the better for everyone involved.
Absolutely.
So yeah, can you tell us who does get involved in the actual conciliation? Who's sitting there at that meeting?
So the conciliation is private for the most part. And I say that because there's a little caveats. But essentially, you're going to have the conciliator, who is an attorney who is trained in conciliation. You're going to have your attorney as well as the other party's attorney. So ideally, it's probably going to be 5 people. It could be more depending on how many defendants there are, or how many plaintiffs there are, or how many attorneys you have, because sometimes you have 3 attorneys. The more people you have in the room, in my experience, the more likely it is to not resolve, because everyone has a difference of opinion. But generally, they all sit there, they have a meeting. Conciliation is similar in nature to mediation, where they will talk to each of the parties separately, and they will talk to each of the parties jointly. So you can get a better sense as a conciliator as to where there may be movement, what they may really be looking for. And obviously, sometimes you don't want to show your full hand and go, hey, this is what I have, this smoking gun. You might want to say that to the conciliator so the conciliator can either soften the blow or say, hey, this is something that you really need to consider, because if this happens, the judge may rule against you. So the conciliator does have rights to voice his opinion on the case, which is different than mediation. A mediator can never voice their opinion. Conciliators are going to voice their opinion on the foundation of your case and how strong or weak it is.
And I think that's really great, because you almost need that coming to Jesus talk because people are kind of in la la land with sometimes with what they can get and what they can't. And sometimes it's because they saw something on TV or they heard that their neighbor or family member got XYZ, but everyone's situation is different. And oftentimes the laws change or they're different in different states. You really don't know unless you talk to your attorney about your specific case. So if someone is telling you this is what the law is and they're actually a professional, it's better to listen to them over your neighbor.
And I'll just one up that. I think another issue is that, people often say, well, yeah, my attorney said this, but, Nicole, I can really do better. Okay, great. And, I'll go to conciliation and I'll zealously represent you. But sometimes it's nice when the conciliator says, well, I have to say that what your attorney is asking for is completely unreasonable. And I'm going, yeah, that's what I told you. But I think that sometimes when you hear it from another party that doesn't have a skin in the game, that isn't saying, oh, I'm going to milk you for your money, that's not the goal here. The goal is to give you good, sound advice. And sometimes that good, sound advice, even though it's coming from me, when it comes from the conciliator that's the exact same, all of a sudden it makes sense. So it lets people kind of think about, well, she was right. Maybe I need to take her advice and move this in a different direction.
Yeah, you definitely need that sometimes. And you don't know what that other attorney, where they're coming from. I mean, they could have a ton of cases and not even really read what was going on with this, not be prepared. They might actually do most of their work in another state and have no idea what's going on in your state. And so I highly suggest getting Nicole Reeves Lavallee. If you have an issue and you're going through a divorce, or even if it's just another family matter, you're not divorced, you're a couple, you've got kids, or whatever the case is. There's a lot of different situations in family law. Give her a call, because she will tell you straight what you can expect, and she will give you options. And she will also tell another attorney that is off in left field that they are off in left field, and that's actually in case this is the reasonable thing to do in this case. And she's helpful with that. And it is nice, I'm sure, to have a conciliator back you up on that. I'm sure you've seen that happen a number of times.
Too many to count, I'd say, unfortunately. And I think, again, it's that person in the robe or it's that neutral third party that all of a sudden the light bulb goes off and goes, oh, maybe it's true. But whatever the case is, the point is you're hearing it again. When you hear it more and more often, you start believing it. You start understanding that this is really what I can do. This is the best I can do. This is what I'm going to hope for. So now it allows you to kind of build that ability and willingness to try to resolve the issue. Now you're not, kind of stuck and going, I'm right. You're going, well, okay, so I'm not as right as I thought I was going to be. So let's get as much as I possibly can out of this deal. And a lot of times that gives you a difference of opinion, just lets you change your entire attitude.
It's so true. And I'm sure that it's really helped move a lot of cases forward that tend to just sit still. And we've seen that happen a lot. I'm sure you've seen that happen a lot, where somebody is stuck thinking they're going to get this thing. And so they just sit there and they won't sign a divorce agreement until they get this thing. And years could go by if they don't go to trial. And everybody's miserable. No one can move on. And it really does help to have somebody say, hey, actually, you can't get that thing. So let's just sign the papers and move on. So why don't you tell me how we can get a conciliator?
So you do have to request it from the court. So again, it's offered in all the courts. You basically just have to talk to the clerk or talk to the judge. Each of the processes are a little bit different in each court, but you basically have to talk to somebody that works for the court system. And generally speaking, the judge will automatically sign a court order that says, yes, go to conciliation. And right now in probate court, we do need to have that form in order to start conciliation. In superior court, you don't need the form. So it kind of depends on which court, again, where you're at. But once you get that form, you certainly can go and start conciliating almost immediately, depending on everyone's schedule.
How long does it typically take to do a conciliation?
Once you get everyone's schedules in sync, because that's probably the hardest part about this whole thing, especially when you're talking about 5 or 6 people. But once you get it in sync and you actually have the conciliation, you're looking at an hour to 2 hours, probably max. We just did one the other day. It was 30 minutes long, but he also said, oh, by the way, we're going to set up a second date and we're going to have a follow-up, and this is what you're going to do in the meantime. So it was a shorter conciliation because the issues were narrow, but he also came up with a solution, and we're going to see if it works, so that when we come back in 6 weeks, if it works, we're going to either come up with other ideas to expand that, or we're going to change it if it doesn't work. So it's really, again, at the mercy of the conciliator, but generally speaking, they're going to give you 1 to 2 hours, if not more time.
Yeah, and again, it's in the best interest of everyone if an agreement is reached. So what happens if an agreement is reached?
Again, kind of depends on what kind of an agreement it is. Again, in this one scenario I just said, it was a temporary basis. We're not even going to go into court because we're not going to worry about getting a court order between now and the next 6 weeks. It's going to take us just that long to get into court. But we're going to try out this. If it works, then we'll address it. We'll certainly have a court hearing, I think about a week after that, which we have planned, and then we'll make it a court order at that time. It may be a temporary order or it may be a judgment, depending on, again, how satisfied both parties are with that.
And that makes a lot of sense. And I was almost expecting you to say, we have a parade. An agreement was finally reached between these people that hate each other. Now, if there is no agreement reached, sometimes there is a sticking point, like we mentioned earlier. What happens then? Cage fight?
Well, it's not the parade, unfortunately. But, it depends. Again, a lot of times we don't resolve all the issues. But I can honestly say I don't think I've ever walked away from a conciliation with at least resolving one issue. So one issue that maybe we're on the fence with, maybe we could work out maybe something minimal, like, hey, we worked out the holiday schedule. But guess what? That could be huge in settlement. So again, it kind of depends. We're probably going to reach some agreement on something. So maybe we enter those as a temporary order that simply says, this is what we're going to be doing. Or maybe we go to judgment on those particular issues and go to trial on the other issues. So again, you're not giving up any of your rights. All you're doing is giving up a little bit of time and hopefully peace of mind so that you can resolve it so that the whole case can be over.
Well, I mean, that sounds reasonable. And you're right. If you can get a few of those issues knocked out during a conciliation, then you can save yourself some money and some time. I mean, you can almost even put a number on some of those issues. I mean, you and I have spoken before on, hey, what does it cost to fight over custody? Well, for some people, it's upwards of $100,000. What if you can come up with that agreement and save a lot of money? It makes the conciliation totally worth it.
Absolutely. And I think one of the big things with that is not only is it worth it, But again, if I'm going to spend $100,000 in attorney's fees, or I could use that $100,000 for my child's college education, which would you prefer? And so a lot of times, again, as attorneys, we're going to kind of give you that reality check that goes, what are you doing? Why are you fighting? I just had somebody the other day that says, so she spent $45,000 in attorney's fees, and the most she's going to save is $12,000. And he started laughing hysterically because his ex-wife doesn't see the big picture and all he wants to do is settle it. And, you know, unfortunately, that's the issue, is she just wants to look at, well, you're not getting another penny. And unfortunately, that's a problem.
It is a problem because they really try to make it fair. And if you've been in a relationship for a while, then whatever assets you guys accumulated during that time gets split in half. And they really consider all of the options before they help you finalize that agreement.
Absolutely. I think, you know, it just, you really got to look at that big picture. You got to look at sitting down and going through the numbers. And I get, sometimes it's just emotional. It's how dare you want this? And it's something of sentimental value. Maybe it is the kids. Maybe it's just something, family heirloom that's not worth anything. But again, it's the things that your ex knows about, and they know how to push your buttons, and there's a reason why they're your ex, or going to be your ex. So, you know, from our perspective, we have to do the reality check. And guess what? A conciliator is even better to do a reality check because they, again, have no skin in the game whatsoever.
Yeah, I mean, you would imagine that they just take the accumulation of their experience and seeing all the cases that they've seen in their career, and they just tell you which way they think it's going to go. It's almost like having a divorce bookie.
Well, that's one way to look at it.
You know, I try to make you smile. So, well, is there anything else that we should know about conciliation before we let you go? Any gotchas?
I think, you know, I think that, again, it goes back to, you have to be willing. You have to be willing to sit down, whether you're in a room, whether you're on Zoom, whatever it is, but sit down with that person that I know you don't like, but sit down, have a conversation. Because if you don't have that conversation with them in that room with a neutral third party, when you're sitting at a desk, on the other side is that ex that you can't really even look at, but then they're going to get up on that stand and they're going to tell everyone all your dirty laundry and then some. And they're going to lie and they're going to say all these things, and you're just going to either cringe or get very, very nasty. And guess what? Neither one of those things are going to be beneficial to you in your case. So while you're sitting across the room from them, think about that. Think about the fact that, again, you're looking at a trial, or you can try to resolve this issue, and you can resolve it. You don't let the judge decide, because the judge might decide that they don't like your voice and they're not believing a word that comes out of your mouth, versus, hey, I know I can walk out of here with an agreement. Again, whether it's in part or in full, that's your choice. But think about that before you kind of get up and say, no, I'm done with this. Because a lot of cases do resolve, and ADR services are phenomenal.
And that's really good to know. And we appreciate your letting us know about this. I mean, so much of your advice saves people tens of thousands and sometimes even hundreds of thousands of dollars. And so it's well worth a listen when you see one of these interviews with attorney Nicole Reeves Lavallee pop up on your social media. And we surely appreciate your doing this for us. So I hope everybody has a great weekend. Thank you so much, Nicole, for coming on.
Thank you for having me.
Absolutely. And thanks to everyone out there that is listening. We appreciate you as well. Goodbye, everyone.